we're going to talk about the fact that millions of people are out there waiting for their visa application to be processed. The State Department recently released those numbers. What you can do if you're one of them to move your application process along. These are the numbers, friends, that the State Department published just recently, showing the number of people in the family as well as the employment-based categories, preference categories, who are still waiting. These individuals are at the NVC, whose case is at the National Visa Center. Cases go to the Visa Center after USCIS approves the petition. Millions of people are also going through the process at the USCIS level, and those numbers are not reflected here. First family preference category, there's almost 300,000 people. The second family category has almost 800,000 folks, guys, waiting. The third preference category for U.S. citizen married children, 617,000. The largest category certainly is the sibling category, 2.2 million people. There are about 170,000 people in the employment-based system who are currently pending at the National Visa Center. What can you do about this? Well, the first thing that you can do, friends, is you can seek expedited processing, asking the National Visa Center to submit on your behalf a request to the U.S. Embassy in your country for an appointment, a visa appointment. This blurb that I have here on the screen comes from our February 22nd newsletter. And we explained that you can seek expedited processing if you have some sort of humanitarian reason to do so, such as a severe medical condition, or the beneficiary might be aging out of the system, or financial hardship, or the beneficiary is experiencing severe trauma. Now, of course, there are other reasons to seek expedited processing. Work with an attorney to figure out whether you have a valid reason to seek this expedited processing. One thing that you should note, friends, is that your priority date must be current in order for you to be eligible for expedited processing. The second thing that you can do, guys, is you can sue the government, and you hear other lawyers and maybe me from time to time talk about the fact that you can do this if your case has been pending for an unreasonable amount of time, a significant amount of time, and your visa is available because your priority date is current. You can file this lawsuit, work with a lawyer to do this, and it will force the next action in your case. The third thing that you can do is make sure that you've done your part at the NVC level. Check your online account to make sure everything has been submitted. There are no pending messages. Everything is good to go, so that you can become documentarily qualified and be placed in the queue for an interview. Fourth thing I want you guys to consider is this. If you are visiting the U.S. and you've changed your mind about returning home and you're still in lawful status, which means that your I-94 period has not expired and your priority date is current, the visa is available for you, then you can apply for adjustment of status. But be very careful with this process because all criteria must be met in order for this to work. And you should also inform the NVC that you're no longer interested in pursuing the immigrant visa because you're doing adjustment of status instead. So guys, those are the things that you could think about if you're one of the millions of individuals out there waiting for your visa application to be processed. We have great success stories. Go to McBeanlaw.com/success to read what we've done for others in a similar situation, and how we might be able to assist you. We work on complex marriage cases, waivers, motions, appeals. We appeal decisions, denials. We do cancellation of removal, stay of removal. We also do adjustment of status in immigration court, removal of conditions, naturalization, VAWA or domestic violence, green card pathway, U visa for crime victims. We also work on asylum cases, special immigrant juvenile status, widower or widow, green card pathway, We also do TPS, consular processing, problems that people have at the embassy level. We work on notices of intent to deny or to revoke, mandamus, as I've mentioned in this video, the non-immigrant visa waiver. And then we also do employment-based pathways here to a green card, EB1, EB1A, EB2, EB3, EB4, EB5. We also do some non-immigrant work visa applications as well, the O1A, the L1A, H1B, and some others. So guys, reach out to us. We'd be happy to talk with you about these options. Also, before you go today, don't forget that we have a terrific free download that answers the top 25 immigration questions that we've received. So go to McBeanLaw.com and download your free guide. I hope you found this helpful. Be proactive if your priority date is current. Once it's current, it gives you a lot more leverage to move forward with the options that I've shared with you in this one. Expedited processing, if you have a good humanitarian reason to do so. Suing the government for the unreasonable delay in your case, and ensuring that you've done everything possible that's in your court to do at the NVC for those who have a visa and they're here visiting the United States and they meet all of those other criteria that I've discussed in this video. Applying for adjustment of status is also an option. I hope you found this helpful. Thanks so much for watching. I get excited every time you guys come into the office to meet with me. We're doing in-person consultations. Reach out to our office and we'd be happy to meet with you in person. Thanks so much. Share this with others and I will see you in the next one. Bye-bye.